Okay, student. Today the topics that we are going to discuss is relation of partners inter se. This topic actually are going to discuss the relation of partners between partners and another partners. Okay, this is not between the partners and outsiders. So we are going to discuss on what are the rights actually of the partners towards each other. So if there is an agreement, of course, we are going to depends on the agreement. So this is agreement can be either oral or a written agreement. So if it's being done expressly, it is easier. However, it's impliedly, then of course it will be quite difficult. So if there is an express agreement, according to Section 21 of the Partnership Act, it provides that the rights and duties of partner as ascertained by agreement or defined in the Partnership Act. So the word is all defined in the Partnership Act, whereby it means that if there is an agreement, we are going to follow the agreement. If there is no agreement, then of course we are going to follow the Partnership Act. And these agreement can be varied, or this provision or the Partnership Act can be varied by the partners through consent of all partners. So if there is no agreement, the provision of the Partnership Act is under Section 26 of the Partnership Act. So let us have a look at the rights of partners under this Section 26. So the rights of partners with regards to contribution, this is under Section 26A. So all the partners actually, they have the right to contribute equally in the capital, and because they have contributed equally, they have the right to get an equal share of the profit, and under the situations, they will also share equal losses of the said firm. So if the contribution is unequal, the presumption is that there is an agreement in existence between the partners, and their right to the share of profit actually will be based on the amount of their contribution. So meaning, if the contribution of capital is unequal, the presumption is that there is a written agreement, or maybe an agreement, an oral agreement exists between the said partners. So sometimes the contribution of capital is not in the form of money, however, it's in the form of skill and knowledge. So the contribution is in the form, though the contribution is in the form of skill and knowledge, still this is taken as an equal contribution to the said capital, meaning these partners who does not contribute money in the form of capital can still share the equal share of profits and also equal share of losses, unless there is an express agreement which said otherwise. So in general, the partners will actually share an equal share of profit and equal also contribution towards losses, even though the capital which is contributed by the partners is actually unequal. Okay, so what about indemnity which can be claimed by one of the partners against the other partner or against the firm? And this situation is governed by Section 26B. These are the situation actually when the partners have incurred costs or have incurred personal liabilities or have made payment whereby he did something which is in the ordinary and proper conduct of the business of the firm, or when actually his action is necessary for the preservation of the business or property of the firm. Then under that situation, he can actually claim to be indemnified by the firm and also the other partners. Okay, what about advances made by a partner to the firm? Advances meaning is some sort of a loan which is been given by the partner, which meant he gave more than the agreed contribution, more than the agreed capital that he's supposed to contribute. Then under the situation, this advancement which is more than the capital which he is supposed to contribute will be considered as a loan. Since it's a loan, of course the firm need to pay him interest. So number 4, this is interest on capital. So just now we have discussed with regards to the advances which is made to the firm, whereby this will be considered as a loan. And as I told you just now, since this is a loan, then the partners actually is entitled to an interest. And number 4, this interest actually can be paid to the said partners only if the said business already gained profit, and this is a net profit. So if there is no net profit, whereby it's only whereby it's only gross profit, then of course this partner which have we have given loan or given advances is not entitled to claim the said interest. So okay, number 5, this is under section 26E, the management of partnership business. So under the provision of the company's the provision of the Partnership Act, all partners have the right to be involved in the management of the partnership business. And if let's say there is an agreement excluding this right, it has to be clearly defined in the said agreement. So what about remuneration? Number 6, this is section 26F. So partners is not supposed to receive remuneration. Okay, so partners they have to share the risk. So meaning if there is profit, then they are going to share profit. However, if there is losses, then they will also share losses. So in the case of Chua Kan Seng versus Boon Chai Sampopong, which I have highlighted to you earlier, so whereby in this case, this involves a salary partner, and the court held actually a salary partner actually is not a partner, because partners, they are not supposed to receive salary. They are supposed to share the risk. They are supposed to share equal losses and equal profit. Okay, so this is number 7. Okay, number 7, introduction of new partners under section 26G. So whether partners is entitled to introduce new partners to the said firm. So this can be done only with the consent of all the existing partners. And if there is contrary intention, it have to be stated in an agreement. So in the case of Bernie versus Reed, what happened in that case? The father had proposed his own son to become a partner in the said firm, and actually this had already been agreed in the partnership deed, meaning there is an agreement, and in the agreement they have agreed that he can take in his son as the incoming partners. So at first, all the partners agreed, but later on, they disagree to this. The court held actually cannot. Why? Because in the agreement, it's very clear, stated that this partner can actually take in his son. So number 8, differences on ordinary matters. So sometimes there is dispute, differences between partners. So if the differences involve day-to-day matters, then it is easier because the majority partners can make the decision. Now, of course, the decision must be in good faith. The decision must be made not based on a bad motive. It must have a good motive. However, they have to give notice to the minority, give them a chance to give their opinion. However, if that matters which changes the nature of the partnership, then of course it must be with the agreement of all partners. So let's say the differences in regards to what type of pen to be used in the firm, then of course this is a day-to-day matters. Then of course the majority partners can make the decision. However, if it changes the nature of the partnership, so let's say now the partnership, the business is a boutique. So now they wanted to involve in this mining business. So this will change the nature of the partnership. Then under that situation, it must be the agreement of all partners. Okay, so now number 9, what about the partnership books? This is under section 26I. So all partners actually, they have the right to inspect the partnership books. What is actually partnership books? These are all the documents pertaining to the partnership. So the agreement, the account of the partnership, and the other document pertaining to the partnership. Okay, so now we are going to discuss on expulsion of partners. This is covered by section 27. So partners cannot expel another partner without an express agreement being stated that the majority have power to expel. So if it is being stated in an express agreement, it also have to be exercised in good faith. So let us have a look in the case of Green versus Howell. So what happened in this case? In the partnership articles, it allowed one partner to expel another partner who actually is in breach of his duty. However, the partners who is being expelled have right to make an appeal to an arbitrator. So what happened in this case is that the partner later on served a notice of expulsion without giving him opportunity to be heard. And the court held this notice is valid. Why the court held this notice is valid? Because I have informed you earlier, if let's say he is not happy with the said notice, he should appeal to an arbitrator. So in this case, we have appeal to the court. So of course, under the situation, this is wrong. Okay, now let us have a look at the duties of partners. So partnership actually is based on the fiduciary relationship, meaning it's based on mutual faith between each other. So this is based on the utmost good faith between the partners, meaning they have to act honestly so that it will benefit the whole firm in all dealings and matters affecting the partnership. So this principle of mutual trust and confidence must be exercised in all time. So this is covered by section 30, 31 and 32 of the Partnership Act. So honesty and full disclosure is under section 30. Unauthorized personal profit is under section 31. Conflict of duty and interest is under section 32. So let us have a look at honesty and full disclosure, which is being covered under section 30. So partners under section 30, in the provision says, partners are bound to render true accounts and full information of all things affecting the partnership to any partner or his legal representative. And this duty is a statutory duty or a strict duty, whereby if a partner fails to exercise this duty, this will be considered as a breach of duty. So let us have a look in the case of law versus law, whereby in that case, a partner sold his share in the partnership to another partner for £21,000, but later on it was found out by the partner actually the value of the assets is more than that, and because of that, the partners now is suing is suing the firm because they have failed to disclose to him the real situation, the real value of the said asset. So what happened in this case? If let's say this case go to court, of course the court will have actually there is a breach of duty, but since this case it has been settled outside the court, and under the situation, we cannot hear actually what is decided by the court, but actually it shows clearly here there is a breach of duty for failure to act honesty and full disclosure. So unauthorized personal profit, this is covered under section 31 of the Partnership Act, whereby the section says every partner must account to the firm any benefit derived by him without the consent of other partners from any transaction concerning the partnership. So partner must not make a profit for himself by making use of his position as a partner or by using information obtained in the partnership business without the other partner's knowledge and consent. So this is what is known as secret profit. However, if let's say, so the important words I have highlighted in purple, so if let's say what is being done of these partners is with full knowledge and consent, then this will not be considered as secret profit. The disclosure has to be full and frank disclosure. So in the case of Bentley versus Craven, whereby this is a firm which they involved in this sugar refinery at Southampton, and Craven is being given the task to buy sugar, and he bought the sugar at a discounted price. Sugar refinery adalah kilang penapisan gula. However, he sold back the sugar to the firm at the market price, meaning he has made a secret profit there. And the court held that the firm was able to claim this secret profit from Cravens. Okay? So in the case of Patirana versus Patirana, whereby this involved this petrol station of Caltex in Sri Lanka, in Ceylon. So actually they are related to each other, so that's why the surname is similar, which is Patirana versus Patirana. So later on, there are grudges between both partners, and then they gave notice to dissolve the said partnership, and they informed Caltex that the said business will be dissolved within 1 month. However, before the said notice expired, one of the partners informed Caltex now, so all transactions need to be done through him. So meaning within that period, he did make profit. whereas actually the partnership is still in existence because the 1 month notice have not expired, and the court held actually in this case because okay, so in the case of Patirana versus Patirana just now, so we said that there is a secret profit. Why? Because the partners actually, the partnership is still in existence because the notice haven't expired yet, and he have informed the main office to conduct all the dealings with him, and during that period he have gained profit, and he did not actually inform the other partners. So because of that, he need to uh, account and pay all the profit he made within that time to the other partners. Okay, so now this is the third, the other section 32, a conflict of duty and interest. So that section says, if a partner without the consent of the other partner carries on any business of the same nature as and competing with that of the firm, he must account for and pay over to the firm all profits made by him in that business. So I have highlighted in purple. The important here is that same nature and competing. So if the said business is not the same nature, we started a new business, however, is not of the same nature, well, this is allowed. Or if it is in the same nature, however, it did not compete with the existing business, this is also allowed. So meaning there are two conditions which need to be fulfilled here. First one, the business must be of the same nature and compete with the partnership business, and secondly, it is being carried on without the consent of the partners. So let us have a look at the case of Bentley versus Craven again. The case we have gone through just now, whereby one of the partners is supposed to buy sugar for the refinery business. Kena beli gula untuk kilang penapisan gula, and he have bought the sugar at a discounted price, and then he sell off the sugar to the said firm with a profit. So in that case, what is business of same nature actually? Court held actually is a question of fact. However, in the case of us versus Benham, this case is much more clearer, whereby the court held actually shipbroking was not of the same nature as shipbuilding. Shipbroking is selling and buying of ship, whereas shipbuilding is building a ship. So court held actually this is not of the same nature. However, because the partner use the same name, H. Clarkson and Company, and this can actually, okay, make the customer confused as whether they are the same firm, and that's why he have been requested and they have been ordered by the court to change into another name so that it won't confuse the said customer. So in Glastonbury versus Tweeds, this involved publication of a newspaper. One is the morning newspaper, and then the other business, which is being carries on by one of the partner later on, is the evening newspaper. And court held actually it is of the same nature. And because of that, of course, this is not allowed because it is competing with the existing business. So, okay, so now I'm going to discuss with regards to the partnership property. Why is it very important to discuss this partnership property? Because if let's say there is dispute between the partners and they wanted to dissolve the firm, then under that situation, of course, we need to determine which actually of the property belongs to the partners and which of the property actually belong to the firm. Which property belongs to the individual partners, which is actually personal properties, and which actually the property belongs to the said business. So, okay, and furthermore, if let's say the company become insolvent, become bankrupt, and the creditors actually, they wanted to auction off the property. Of course, we need to determine which part of the property actually is the partnership property. Okay, so under section 22 sub 1 of the Partnership Act, it states that all property and rights and interests in property originally brought. Number one, all those property originally brought into the partnership stock. Okay, or acquired, whether by purchase or otherwise. Secondly, whether it's been purchased or otherwise on account of the firm. And thirdly, for the purpose and in cost of the partnership business. All these are being called partnership property. And partnership property, this must be applied, of course, exclusive for the said business. And in Barker versus Barclay Bank, the court held actually, and this partnership property must be used and applied for the purpose of the firm and is in accordance with the partnership agreement. So if a partner make use of the property has its own property, this actually is considered as committing the thought of conversion. Okay, and this is actually wrong. And you need to account to the said firm. So the common problem that arises, whether the property actually belongs to the firm or to the individual partners. So if we look at the definition of section 32 just now, so actually there are three elements, three ways how to look at the said property, whether it is a partnership property or not. Number one, as I have highlighted to you earlier, so all property and rights and interest in property which is originally brought into the partnership stock is considered as partnership property, unless there is an express or implied agreement which shows otherwise. Kalau ada perjanjian lain yang menunjukkan sebaliknya, itu mungkin bukanlah partnership property. So, to be much more clearer, let us have a look at the case of Miles versus Clark. So, in this case, this Clark, he has been carrying on this photography business for 7 years. So meaning he is a sole proprietor, he carries on the business by himself and have leased the said promises for the past 7 years. And then later on, he wanted to enter into a partnership with Miles. And later on, they had a quarrel and then they wanted to dissolve partnership. Now the dispute is whether which of the following is actually partnership properties. So number one, the consumable stock and trade, barang-barang yang pakai habis. And number two, the personal connection brought in by the partners. Number three, the lease of the premises. Okay, penyewaan bangunan tersebut, the furniture, fitting and equipment of the firm. So the court held actually since when they enter into the partnership, they only agreed to share profits. Nothing was mentioned about the property. No other arrangement was made with regards to the property. And because of that, the court held that only the consumable stock in trade, should be regarded as partnership property. So, okay, the second way of determining partnership property is whether the property is obtained through purchase or through any other way for the firm. So, if it's been bought by the partnership money, of course, the presumption is that this is actually the partnership property. So unless it's been shown otherwise. So in the case of ex parte Haynes, a few partners whereby one actually traded in Barbados and the other one traded in Liverpool, and the partners which in Liverpool had purchased share in a railway with money belonging to the firm without the knowledge of the other partners. Actually, he bought this share for the firm. Since it's been bought with the money belonging to the firm, court held actually this share actually is the partnership property. So, however, let's say it involves land and they are co-owners of land, then under that situation, if let's say the profit which is produced by the land, then will actually the land become a partnership property. So in the absence of any agreement showing that the land is partnership property, then we cannot say that this land is actually a partnership property. For land, we need to look at the document of title. Okay? So let's have a look at the case of Davis versus Davis, whereby in the case of Davis versus Davis, this involves two brothers, whereby they have inherited this property from their father. And what they did is that they wanted to extend the workshop on the property for the said business. And now the issue is whether this workshop is a partnership property or not. And court held actually there is no intention showing that this workshop is a partnership property. So, okay. So the third way of determining whether the property is a partnership property is through looking at whether the partnership property is being used for the purpose and in the course of the partnership business. So, however, though we said that if it's being used for the purpose and in the course of the partnership business, then we presume that it is partnership property. However, there are situations whereby though it's used in the course of partnership business, it is considered not as partnership property. So let's have a look in the case of Rana Amal. So in the case of Rana Amal, we have gone through this case earlier, whereby this case is with regards to this a syndicate which sell condensed milk. So court says this is a partnership. However, whether the trademark, they have this trademark, ada jenama, which is registered under the name of one of the partner. So now the issue is that whether this trademark actually is the partnership property or not. The court held, based on the written agreement, this trademark does not actually belong to the partnership, and it's not a partnership property, and it is actually a personal property of the defendant. Because why? Because it's stated so inside the agreement. So, okay, as a conclusion, partnership property actually refers, number one, property brought into the common stock of the partnership. Okay. And number two, property which is obtained through a purchase or other way for the firm. And number three, whether it's being obtained for the purpose and in the course of the partnership business. So unless there is a contrary intention as mentioned by section 23, then we can say that this is a partnership property. So section 23 said here, unless contrary intention appears, property bought by money belonging to the firm is deemed to have been bought on account of the firm. Okay? So actually, it depends on the facts of the case to see whether there is such a contrary intention. So such intention may be expressed or implied. So that's why, as what we have seen earlier, in the case of Ratna Amal, so the trademark is supposed to be a partnership property. However, because there is a written agreement showing a contrary intention, that's why court held actually it is not a partnership property, because inside that agreement, they have agreed actually that the trademark belongs to the defendant who have registered it under his name. So, okay, student, that's all under this topic. Thank you, student.